we will hear from the appellant in this case.
Your timer says 15 minutes.
It's just moved.
Thank you very much.
It was set for criminal case. Anyway.
If it please the court, I would like to reserve 7 minutes for rebuttal. My name is Heather MORCROFT. I'm the guardian at LITEM, and I'm here on behalf of the children. This is a case involving domestic violence, and there's been some disagreement as to how many incidents of domestic violence actually occurred in this case. There were 4. The first was in 2001, and that incident was admitted to at trial but was not really testified to.
Counsel, did the department say at some point in here they were just relying on one incident?
The department was talking about what happened in 2005. What happened in 2005 involved 3 separate incidents.
It had 3?
Yes. The first was the incident that resulted in the ex parte injunction. The second was a violation of that injunction, which you'll find referenced at A11 in the record, where the father attempted to remove, to take the children away from the mother. And the third incident was when he entered the home and attempted to kill them. All of those took place around the same time. The incident that DCF was relying on...
What does around the same time mean?
At the end of March, beginning of April.
More than one day?
Yes. I believe that the department was relying on the attempted murder, and I do argue that that is sufficient. However, the fact that these other incidents occurred and that they are referred to in the record and part of the record is also important. This is because of the standard in domestic violence. The standard in domestic violence is that the children are likely to continue to be exposed to or affected by DV. And the fact that there were 4 incidents goes to that, as I'll discuss later on.
Ms. Moorcroft, I guess the thing that occurs to all of us, including the trial judge, is that if the father is incarcerated for some substantial period of time, there's not going to be an opportunity for exposure. And so I guess my first question is, does the record reflect what the prison status of the father is?
At the time of the trial, the father was incarcerated and awaiting criminal trial. So there was no evidence as to whether or not the father would be convicted, of which charges he might be convicted, or what his sentence.
Was he not incarcerated because of the violation of the injunction?
Didn't he have a 6-month sentence for that or something?
He was incarcerated because of the violation of the injunction.
But he hadn't been.
His testimony, however, wasn't really clear. There were 6 different criminal counts against him, and that was testified to.
But the criminal case involving this last act of domestic violence hadn't been brought to trial yet.
Right.
Okay.
That's correct.
What protection would an adjudication of dependency afford that the permanent injunction, which could only be lifted by the judge, afford?
Well,
I thought that was the basis that the trial court based, I forget who the trial judge was, but wasn't that the basis of what the trial judge did?
Well, the trial judge...
Mother went to court, got a permanent injunction, and I don't see right off that adjudication of dependency would afford any more protection and do anything that the mother hadn't already accomplished.
Well, first of all, the trial judge found that because there was no physical harm to the child and no expert testimony as to emotional harm, there was no dependency.
Well, let's assume for the moment that's erroneous.
But the fact is that, and this is where the admission to the 2001 injunction is so important, the mother had returned to the father in the past. Although the mother testified that she planned to get a divorce, this trial was 3.5 months after this attack, and she had not taken any steps to actually do that.
But what good does a divorce do? The divorce doesn't protect the children. It's the injunction that does. And she got that.
That's true.
She initiated that on her own without the department itself.
Yes. However, given the father's history, sneaking into the home, breaking into the home and entering, I'm not sure that the injunction really provides any protection either.
Well, how can the department provide him anything more?
Because if the dependency was there and the department was supervising for, say, 6 to 12 months and keeping track of the children, there would be an opportunity to see, A, if the mother actually followed through with what she planned to do.
In other words, this is based on the department's distrust of what the mother might do. That's what you just said.
Well, I don't like to blame a victim, and I am not suggesting that the mother didn't take appropriate
But that's
steps.
the whole basis of, that really, what it comes down to, it is the basis of your argument, that the mother can't be trusted to enforce the injunction, whereas the department could.
No, it's not the mother's job. Well, the mother would have to pick up the phone
Sure it
and call,
is.
and I would assume that she would. But
It's
no,
certainly her
I'm not
job to
arguing
enforce the
that.
injunction, is to protect her and the children.
Right.
Let me ask you a question. You say in your brief that the permanent injunction is permanent only as to the mother, but it's temporary as to the children. Now, what do you mean by that?
Well, the injunction gave temporary custody to the mother and the maternal grandmother in charge of DCF. So the injunction contemplated that DCF would be involved in this process for a while. There is a no contact order in that injunction against Dad as to the children until further order of the court. So the custody is, the court appeared to assume, and so did the dependency court when it said that a divorce court would take this and resolve this issue. The trial court assumed that DCF, the injunction court, assumed that DCF would continue to be involved. It was a joint custody arrangement with the mother and with the maternal grandmother. So apparently the DV court had some concern that there needed to be someone other than the mother keeping an eye on the children. I don't know that I would go so far as to say I don't trust the mother. The mother is in a terrible situation. She might feel that she had to attempt to placate the father. There are any number of reasons why she might make a decision, and her situation is a true dilemma. She doesn't necessarily have a good decision that she can make if the father is truly determined to go after her. So having more people involved, having more services available for the children for a period of time until everybody felt like, okay, this looks like it's going to be all right, is really, I think, what the statute contemplates.
Counsel, if this father had been convicted and he was beginning to serve a long prison term, would your argument be the same?
I would still be concerned about services for the children, yes, because the testimony shows that the children suffered significant harm at the time, emotional harm, that they continued to be fearful and uncertain, and that they needed to have those issues addressed. I mean, I was watching the news.
How could those issues be addressed better by finding a dependency than by the injunction?
Because the children need services that the department might well should be able to provide.
Well, that's true of any number of people out in society. If you walk down the street here, you probably see some families like that, but is that the basis for intervention by the department when the mother has done all that it seems to me that a mother could be expected to do under these circumstances?
The basis is the father tried to kill the mother in front of the children, regardless, and showed a wanton disregard for the presence of the children. And whatever the mother does.
I'm not suggesting otherwise.
Right. But that's different than someone just walking down the street who might be in a dysfunctional family. The father...
That's a bad guy, but didn't she do everything under the circumstances that she, as a responsible parent, could do?
Well, no. She didn't file for divorce.
Well, but you don't know, well, for one thing, a divorce doesn't protect you against somebody that's homicidal.
Right.
The best protection you can get is not the divorce, but the permanent injunction that perhaps might go with it. But
the best protection might be to move to an undisclosed location, but
the department can't tell her to do that.
Right, absolutely not. But the department can provide services to the children and the mother, if she wanted it, to assist them with the psychological and emotional harm and to assure their safety for whatever period of time. I mean, this case could close. If there were dependency, this case could close within 6 months. But to simply say...
Certainly the department doesn't feel that it could effectuate a reconciliation between these people, does it?
Well, I'm not for the department. I would certainly hope not, no. I would hope that the department would provide services to the children and to the
Such
mother.
as what? You're the guardian ad litem, I understand that.
Correct.
But what services are you attempting to obtain for the children that you feel the record indicates they might otherwise be deprived of?
Counseling services, assessment services to determine what kind of treatment they might need. They're pretty young kids. They might need play therapy. Some discussion perhaps with their mother. Apparently they were questioning their mother about...
Aren't these all things that a responsible parent perhaps would have the opportunity or perhaps should consider?
Well, there's nothing in the record that that was taking place.
But under that theory, any number of parents out there, perhaps including me, I never sought counseling from the department or anybody for my children. That doesn't make me an unfit parent.
And I'm not suggesting that the department find dependency as to the mother. I'm not suggesting that at all.
Well, you've got to pin your argument on this father. I mean, it seems to me he's a risk or he isn't a risk, and that's the only reason.
Right.
Can I ask a couple of questions about the divorce? Why is it of such great concern whether Mom wants a divorce?
I think because Mom returned to this gentleman in the past.
So it's evidentiary.
I'm not sure I understand the question.
I guess if you feel like the reason you are concerned as the guardian is that the mother's returned to this guy in the past, then that's something the trial judge should have taken into consideration at the time that he issued his ruling, correct?
Yes.
And would you guess that that's probably an abuse of discretion kind of review for that decision?
It could be if the fact that that was admitted, it was admitted that this occurred, but there was no testimony about what happened in 2001.
But in terms of what the trial judge decided to do here, that was one of the factors that I can't remember who the judge is either.
Mara Smith.
That she had before her and considered at the time that she entered her order, right?
Yes.
Well, now, why would we want to intervene on that basis, since she had the live bodies there? She could look Mom in the eyes and look at the children and make a determination based on whether or not the divorce was all that necessary. I guess I'm confused by why that piece of evidence is so critical to this decision if the trial judge had it before her and she took it into consideration.
Well, I believe that as long as the mother chooses to remain married to the father, she is giving him additional power. He has a legal relationship with her that allows both of them to go back into the court.
I guess I'm not making myself real clear. I understand that's what your concern is.
Right.
But my concern is what our function is. We're a reviewing court, an error correction court.
Right.
If the trial judge had the fact that she was not seeking a divorce in front of her at the time that she made these decisions, and if that is a decision which is not an abuse of discretion, meaning that it's a decision that rational people could disagree about, why would we want to upset that determination given the presumption of correctness?
It's an evidentiary determination. What the mother testified to was that she planned to seek a divorce.
Judge had that.
Right, but that's totally speculative. She had not actually done.
The judge had it. I guess I'm not making my point very clearly.
Counselor, you're down to your 7 minutes.
I know. I need to
Okay.
take it.
Thank you.
$35? I had it right the first time. Okay.
No, it's 18 now. Stop.
It's too complicated.
Well, good morning, Your Honors. May it please the Court, I'm Ryan Truskowski, representing the father, J.H. The guardian ad litem's entire position in this case is based on a faulty premise. There is only one incident of domestic violence in this case. GAL refers to, in her statement of facts in the brief, 2001 injunction. This came from a statement from the mother's attorney. This is not evidence. There was no testimony on this issue. The injunction was not admitted into evidence. We don't know what the basis was. If it does exist, we don't even know what the basis of it was for. In the department's dependency petition, there are no allegations of past domestic violence. So even the issue would not even have been properly before the trial court. It wasn't even played. On page 4.
Counsel, based on some of the cases out of this court, that doesn't really matter because this was such a horrific incident of domestic violence.
That's true, but as the GAL notes on page 17 of her brief, that the standard is whether the harm from the domestic violence is likely to continue. And in this case, the mother acted like a perfect parent. She ceased all contact with the father, obtained a permanent injunction, announced her intent to get a divorce.
Well, I disagree with your brief, and I disagree with the statement of the trial court that this one domestic violence incident isn't sufficient to base a finding of dependency. I think it is, and based on a number of the cases written by this court.
That might be true if the parental relationship is going to continue.
All right, well, you can now argue that incident, but this is enough to get us started, put it that way.
Okay. If the court was going to take a position that just this one incident was enough, we would be blaming the victim. We have a parent who did not have knowledge that this was going to occur. We have a parent who is a victim. After the incident occurred, she did all the right things. The purposes of dependency is to fix problems of parents with their abuse, abandonment, or neglect. And in this case, we have a perfect parent. We have a parent who was declared non-offending, the mother. The guardian ad litem did not object to that position below. And the fact that one horrible thing did in fact occur, but the parent acted like a good parent in response to that incident.
When I, in effect, raised this to your opponent, her answer, if I understand it, was that the woman has not undertaken to obtain a divorce. What is your response to that?
Well, that was, the trial court believed her statement that she was going to get a divorce. And it was only 3.5 months after the incident. You know, the mother testified that she was not going back to him, and the trial court found that credible, and that's supported by competent, substantial evidence.
How long, if you know, was the mother in the hospital?
I do not know. Okay. I don't recall.
That's okay.
Well, counsel, what if, just what if, this father was out on bail?
And that's not an issue for DCF. That is an issue for law enforcement. DCF is there to correct parental behavior. In this case...
Well, what if he was out roaming around? I mean, would this be a correct ruling?
Yes, it would, because the mother testified that she wants nothing to do with him. The mother testified that she was ending the relationship. And that would be dispositive of that. But he is in jail, and he is facing a long incarceration.
I hope so.
Correct. I mean, when the parental relationship is over, such as it is in this case, as the trial court found, the children don't need protection from DCF.
What is the mother? Has the mother indicated a position on whether the parental rights of the father should be terminated?
I don't know if she has. I don't know if that's
nothing in the record on that.
It's not in the record. As far as I know, the department is not. Well, I don't know either way, to tell you the truth. Another interesting thing, the GAL is trying to argue a prospective abuse theory on appeal, but did not argue that below. did not preserve that for this court's review. There's a case, Nicholson v. Williams. It's a federal case out of the Eastern District of New York, 2002, where the state of New York, as a policy and practice, was taking children away from mothers of domestic violence, but first-time acts of domestic violence, in essence, blaming the victim. And federal action got involved and kiboshed that.
But this,
Kibosh, that's a
the mom
legal
isn't
theory.
being held.
I'm sorry.
The mom isn't being, I mean, we aren't appealing, dependency action didn't relate to her, it relates to the father.
True, but the legal standard is whether this cycle of domestic violence is likely to continue. If there's no relationship between the parents, then it's not likely to continue. It's an unfortunate...
I don't see how you can say that. If the man lives next door or lives somewhere, maybe they have a divorce, but he still has rights as a father. It seems to me that they are at imminent risk
Well, if he was out of jail,
if he's out.
that is an issue for the criminal justice system. Here we're correcting parental behavior. The fact is that if there's no ongoing parental relationship, I don't want to keep on repeating myself, but that there is no cycle here. It's a one-time incident.
Well, I respectfully disagree with you on that point.
Your opponent seems to be suggesting that a finding of dependency would afford more protection than the injunction. Is that correct or incorrect?
It's not. I mean, she's trying to say that the children need services. They don't. And they have a fit parent taking care of them.
Well, the one service that they need is protection against the father, right?
Correct. And she did that by obtaining the permanent injunction. It has nothing to do with DCF.
Is this injunction temporary as to the kids and permanent as to the
There's no
mother?
expiration date for it, so it's permanent.
What's the practical difference between the termination of parental rights and a permanent injunction against seeing the children? I think your opponent mentioned provision of services as
Well, for this case, there's no practical difference. I mean, the mother has done all she can legally to rid herself of the father.
I must tell you that my gut reaction is that I would like to see this guy out of their lives, but I can't really come to grips with how what the trial judge has accomplished would be any different than if a termination was effective.
I don't see a difference. I don't see what effect that has.
Well, could the department at this point begin a termination
Sure.
proceeding against the father?
Sure. So can the guardian then?
So if the father is not imprisoned for a long period of time, that is out of children's lives because of imprisonment, the department could, and he attempts to recontact these children, the department could start a dependency proceeding once again.
Correct. That's always their option. Is there any further questions? Thank you.
Thanks.
So, Ms. Moorcroft, is that correct? If the father is not in prison for an extended period, and he attempts a recontact of the children, can DCF at that point seek to terminate his parental rights?
Well, the injunction was issued by the DV court. The department would have to find a new incident of abuse or neglect. There is a very...
Suppose it's simply the violation of that injunction, like trying to contact the children.
I don't know that would be in and of itself sufficient, no. Nor do I know if the current incident would meet the egregious requirement for a termination at this point. There is a very practical effect to this, however. For example, let's say he gets out again and he kills the mother. He's then going to be the only living parent with intact rights. And the law is going to assume that he should get those children back. So A, he has another motivation to try to kill the mother, and the children are at risk at any time. In addition, the standard that this court has repeatedly articulated in domestic violence cases is whether the children are likely to continue to be exposed to or affected by the domestic violence. That initial incident is most likely going to affect these children for the rest of their life. I was watching the news this morning, and they were talking about the reactions that soldiers have to the horrible things that they see in war and how long that can stay with them. These are young children watching their father try to kill their mother. I can't imagine that that would not continue to affect them for the rest of their life and meet this court's standard. The permanent injunction that we are discussing specifically contemplates DCF remaining involved. So while the no contact orders are separate from that, I don't see how the mother can argue that, oh, DCF is gone, there's no difference, I have the injunction. Clearly, the domestic violence court thought that there was supposed to be some unification, even though this unified family court concept.
Is the mother a party to this?
The mother is always a party in a dependency action. And the mother, in fact, argued to have this dismissed as well. So
She argued to have what dismissed?
this case dismissed against the father. And she may well have done so because she was afraid of the father. I mean, I'm not going to speculate as to, I'm not going to blame the mother for anything. She has taken many appropriate steps.
She may have wanted DCF out of her life, too.
She may have. But then how is that going to affect the permanent injunction that's out there that says joint custody with mom and DCF in charge?
Ms. MORCROFT, let me turn you to just one other question. I'm sorry. What is DCF's position vis-a-vis the outcome of this case?
DCF attempted to join me, and there was some sort of time problem, and they were unable to join, but they do not oppose me, and they do not support the other side. And they did file an answer brief to that.
They didn't file a notice of appeal, their problem.
Right.
They filed a brief that was frankly confusing.
Yes. Well, that's my understanding of their position, is that they agree that there should have been independency.
So you say this permanent injunction, which is out there, does not sufficiently protect the children from the father because it contemplated DCF being involved?
Right. And
Should the mother go back and get another one?
quite possibly. The problem this court faces is a lot of this depends on things that have happened after the trial, and none of us know what those are. I specifically didn't look because I didn't want to be tempted to try to share them with this court. So that does create a problem for all of us. But I believe on the record available and the standard already articulated by this court, there is sufficient reason to order the lower court to find the father dependent and provide what services are available for the length of time available.
No, it strikes me that the real problem is that the order here was a bit premature because none of us seem to know what exactly happened to the father. Would you agree that it makes a difference if the father is incarcerated for the rest of his life?
Yes, I think it would make a difference. I think it would make a difference.
How do we accomplish that?
Well, one of the alternative remedies that I suggested to this court was that you return the case with some direction as to obtaining additional evidence prior to making a determination, if you're unwilling at this point to simply reverse the lower court.
Not sure I know exactly how to accomplish that, but that's an interesting point of view.
Thank you, Your Honor.
Thank you. Thank you. That will conclude our arguments for today.
I'm exhausted.
I bet you are.